As part of your proxy statement filed with the SEC, you will disclose information about the number of board and board committee meetings, as well as whether your directors attended fewer than 75% of the meetings they were supposed to attend. Today on Zippy Point. I'm Brock Romanek, and I'm a big fan of yous. Before I bring in our guest to explain how to provide this disclosure in more detail, let's run down some of the basics. The legal requirements. Item 7B of Schedule 14A refers to Item 407B of Regulation SK. Item 407B of SK lists the disclosures about board meetings and board committee meetings attendance. What to disclose. This is a pretty simple disclosure requirement. The only issue that arises is if you have a director who attended fewer than 75% of the meetings they were supposed to attend. Item 407B1 of Regulation SK requires disclosure of all meetings of the board, regardless of whether the board meetings are regular or special. You include all meetings, regardless of whether they were held in person, conducted via telephone or video conference, or a mixture of the few. You might have an in-person meeting where someone's attending virtually or by phone. You don't have to indicate where the meetings were in person or not, and I haven't seen many companies voluntarily disclosing whether that was the case, especially nowadays when so many board meetings are virtual. However, you only count official board meetings, so you don't count the unanimous written consents, you don't count teleconferences that were informational only, that weren't noticed by state law, minutes weren't taken, that sort of thing. You don't count executive sessions that are just breakouts from official board meetings. Your minutes will help you figure out how to treat multi-day board meetings for the purposes of this disclosure. Did more than one official meeting get called to order? Did more than one get noticed if required by state law? Probably not, but maybe. Under item 407B1, companies are required to disclose the total number of meetings for each key board committee. So that's the big three, the audit, nominating, and compensation committees held during the last fiscal year. 407B1 only requires disclosure for board meetings and board committee meetings held during the company's last fiscal year. So any meetings held since the end of that year, so between the time the fiscal year ended and the time you're drafting your proxy, don't include those meetings in your count here. Those meetings after the fiscal year end are counted towards your next proxy disclosure. Director attendance. So under item 407B1, companies are required to identify any incumbent directors who during the last full fiscal year attended fewer than 75% of the aggregate of the total number of board meeting and board committee meetings that the director served on. So this includes any board committee, not just the key board committee. So this goes to committees that are beyond the audit, nominating, and compensation committees. So attendance at any board committee meeting gets counted here, both in the numerator and the denominator. So this trips some people up because the math is a little bit different than before when you were just counting how many board meetings were held, how many key board committee meetings. Now you're taking into account all board committee meetings when you're doing your numerator and denominator. You get the idea. As you'll soon see in some of the examples I share, companies like to tout their high level of attendance that their board had as a whole. If they have it, show it off if you can. So they disclose a high percentage and a weighted average typically, and perhaps even in a graphic. Show it off if you can. You might not get the chance next year, and note that you can show off in the years that you can, but you don't have to just stick to that type of disclosure the following year if your percentages go down for some reason. You can be selective from year to year, and people are. Let's talk about who an incumbent director is. We'll also interpret the definition to be whoever is on the board past the annual meeting. So it would include those not standing for re-election, but they're still on the board up until that annual shareholder meetings. But this is a little bit unclear because there's no SEC guidance. If a director has joined the board sometime during last fiscal year, the 75% or fewer calculation is still conducted for that person for the period for which they served as a director. So if a director joins partway through the fiscal year, the numerator is how many board and committee meetings were attended during the period served, and the denominator is all the meetings held during that same period, the committees that that person was on. It's a bummer when you have one or more directors who missed a quarter of their meetings. You have to identify them by name in the proxy statement. This can be embarrassing disclosure because people will read it, including the proxy advisors and your institutional investors. So many companies provide an explanation of why they missed so many meetings. And hopefully they have good reasons. If they don't have good reasons, then you're probably not providing mitigating disclosure. But it's a good idea to disclose mitigating circumstances if you have them, because the purpose of this disclosure is to enable shareholders to evaluate whether directors have shirked their duties. So if a director missed some meetings because of health issues, shareholders and proxy advisors are more likely to understand than if the reasons are left to the imagination. Location, where does this go in the proxy? The SEC has not dictated any required spot, but typically with the other director-related disclosures, either in a standalone governance section or as part of the section that describes the proposal for the election of directors. Let's parse some examples. Here you have Amazon doing the standard, just disclosing that all the directors have met the 75% threshold. Here's Prudential highlighting that on a combined basis, they attended 99% of their meetings. That's awesome. Microsoft does a great job here. They provide some detail about how some of the board meetings are different than other board meetings. They have a strategic retreat. They have 2-day meetings every quarter. I really like how they give you a full bullet of disclosure. Cognizant has a great graphic as part of its disclosure, giving you the weighted average. And Cognizant also had a director who could make 75% of the meetings, and you can see the explanation of why not here. I'll end by just noting that Cognizant does this cool thing. They have one-on-one meetings between directors and members of management or highly performing employees after each board meeting. This is not in the section regarding the director attendance. This is really a CEO succession / human capital management kind of thing, but I thought I threw it in there because it's cool and you should know about it. Note that I do have a separate vid guide on director attendance at annual meetings, a link to which is beneath this video. My guests today, Bob Lamm and Jane Storero, are two of my all-time favorites. Bob has seen it all, done it all, been there, done that. He's been in-house at 6 different companies over his storied careers. 6. The last being Pfizer in New York. He's now a shareholder of Gunster down in southern Florida, still as busy now as he was 45 years ago. He contributes to that firm's Securities Edge blog with a regular column. So I've known Bob 20 to 25 years. I've known Jane even longer. She lived in the DC area for a considerable length of time and has now relocated up near Philadelphia, where she has her own consulting practice. She's been in-house with Pepco here in DC and done the law firm thing too. I'm Brock Romanek, today on Zippy Point.
Quick Zips by Zippy Point.
Quick and dirty. So Bob and Jane, thanks so much for doing this. Another topic that really doesn't get much coverage out there, but it's important. You're dealing with your board of directors, and it's a sensitive topic as always. And so the first question for you, Bob, is how much do directors actually hate this disclosure when they miss more than 25% of their meetings?
Well, in my experience, they probably don't hate this disclosure as much as they hate the consequences of this disclosure, which is that fairly often when a director attends less than 75% of the meetings, that's reflected in the vote they receive. And even if all board members get above 90% vote, just to pull a number out of the air, if Mr. or Ms. X gets 91 and everybody else gets 96, they're very sensitive to that. So I think in general they are sensitive to it. I sometimes wonder if when board members look over drafts of the proxy statement, the only thing they do is a word search to see where they're mentioned. So they do focus on it. Again, I think more because of the consequences than the disclosure itself.
I think that's right on the money, Bob. And I once had a director say to me when he saw this disclosure, my neighbor is going to see this. He's a shareholder. And he was very concerned about what, others would think because it's out there for the world to see.
Yeah, and I mean, you can argue about some other bases on which investors vote against directors, but it's kind of fair to say that the minimum you ought to be able to do is show up. So they're vulnerable when they miss the meetings, which may make a segue into your next question.
Yeah, Jane, so how hard is it to write mitigating disclosure when a director has missed more than 25% of the meeting? Missed more than 25% of the meetings?
Well, I think the answer to that is it depends, because if the director has a legitimate excuse like an illness or a family emergency or something that was clearly unavoidable that you can explain, it's not that hard for a skilled securities lawyer to draft something that addresses that without giving away too much of the personal information about the director. Now, if the director just is overboarded or has too many other things going on and they just missed, and there's not really a good enough reason for that, then I think it's more difficult. And I'd like to think that as securities lawyers, we're masters of our craft, and we can, craft language around just about anything. But, frequently that gets seen through by institutional investors and ISS and folks that are looking at these things closely.
Yeah, I would think it's better to even be silent in your disclosure than disclose that the director had a conflict in their schedule. But I guess,
but I think there, Brock, even then, I think Jane's initial answer was the best one. It depends. I've seen disclosures where a director, you can argue whether he or she was overboarded or not, but he was on, in this case, he was on another board, the board of the other company that was going through a major M&A transaction, and he had to sort of assess his priorities, and he attended the other board meeting. And the way it was described in the proxy statement was basically, a company on whose board he served was involved in a major transaction, and he missed the meeting unavoidably or something. But at the same time, and I do remember which company it was. It wasn't one that I worked for, but the disclosure said, this situation basically is not expected to recur, and Mr. Jones, has committed to improving his attendance in the future. So even there, while it's not a pretty sight, as Jane said, we're talented. We can try to draft mitigating disclosure. I mean, sometimes the facts are just crappy and you can't deal with it. But I think even in that circumstance, you can make it a little bit better than just saying he didn't show up.
So Bob, what about the proxy advisor policies? Do directors get put in a box automatically for missing more than 25%?
I think in general they do, and even if they don't get put in a box because of, I don't know that a director would necessarily get a negative voting recommendation just because of that, but it certainly doesn't help. And as I said before, I think reasonable people would agree that the least a director can do is show up for meetings, and to me it's kind of inexcusable. Absent an excuse, a good excuse, it's inexcusable for them to miss that number of meetings. So, I think it's a fair ding against a board member if he or she doesn't show up.
No, I agree. And I don't think the proxy advisory firms look kindly on that. I've sometimes seen a vote against the chair of the governance committee or the chair of the board if they're not enforcing their policies in this regard as well.
One thing we didn't talk about, and I may be out on a limb here, but I've always tried to disclose what the actual attendance was year in and year out, and I didn't phrase it as each director attended at least 75%, because very often the attendance is much better than that, and you don't have to disclose it on a name-by-name basis, but you could say the average attendance at board meetings was 90%, which it very often is. And I won't name the company, but when I started at a new company a few years ago, they always said at least 75%. And I said, what was the actual attendance? And it was like 89 or something. And I said, well, why don't we just say that? 89 is better than at least 75. Oh, we don't want to say that because what happens if the attendance is bad one year? I said, well, first of all, when did that last happen? It turned out it hadn't happened for like 16 years. And I said, and if it ever does fall below, at least you can say, every other year, everybody's attended 89% of the meetings. This was obviously an anomalous year. We're going to do what we can to see it doesn't happen again, et cetera. So I think this is an opportunity that a lot of companies miss out on to accentuate the positive and talk about what are generally high attendance figures.
That's a great point, Bob. And, a really good place to put that kind of disclosure is in your corporate governance highlights up front in the proxy, and then in the back where you talk about the directors, you can always write the SEC language in the proxy statement about the 75%. And then this way, that point gets really highlighted for everyone, which I think is important.
Yeah. And, to me, it just speaks to a slavish adherence to whatever the SEC rules say, literally verbatim. And you can make disclosure, not always, but in this case, you can usually make disclosure more positive than that.
Yeah, and some companies are using graphics in the introduction and the basics. The first part of this video, I showed one company who did that where they had a high weighted average. And so they used a graphic to illustrate that in this part of the proxy.
I realize I just preempted question 4. I hadn't focused on that, so forgive me.
People out there don't know we have ordered questions.
That's true.
We're just making this up as we go. So Jane, how do you adopt a director attendance policy?
Well, I typically have included the director attendance policy as part of the corporate governance guidelines to the extent possible, and I have my druthers. But I have on occasion also had just a board resolution or a simple standalone policy regarding this issue. I think, the key is you have to work with what you have. It's always good when you're starting from scratch. You can tailor the corporate governance guidelines and make it really work. But, in a pinch, I've just adopted a board resolution at a meeting, and that was my policy.
It doesn't necessarily have to be in your corporate governance guideline. It could be in the board resolution or just in the minutes. And
yeah, I would, all things being equal, as Jane said, sorry to be avoiding controversy, but I totally agree with her. All other things being equal, I'd put it into the governance guidelines. Among other things, I found that when you put stuff in resolutions, a new director comes on board and, you forget to give them the resolution that said they should do X. So having all those guidelines and you can more easily say, these are the things that you have to comply with. It's all in one neat little package. But again, exigencies may create other challenges. So you've got to do it in a resolution. You do it in a resolution.
I mean, this may be a little off topic, but also it's really important when you do the director onboarding to make sure that they have all these policies that apply specifically to directors so that they know what they have to do. And I've even seen some companies have a director agreement, for lack of a better word, that says thou shalt not do this, this, and this, and thou shall attend board meetings, just to make sure it's clear and out there, and the director signs what they agreed to and they get a copy.
Right, and even during the director recruiting process, you're making sure your calendar, if it's set way in advance and it's set in stone, that they automatically don't have a conflict even before they get on the board.
Yeah, it's funny because that's not always, but especially more recently, that's like the first thing you do when a director candidate is presented to you. Obviously, you have to run the Clayton Act traps and do all that other stuff. But I found that was really the key, because occasionally you find a board member who's literally got 4 out of 5 dates already committed. And in one case, they said, look, this is not a good year because you're going to miss the meetings. What's the schedule like for the next year? And they would just defer adding him or her to the board. But that's like critical. And if you don't do your homework in that regard, you're going to look foolish, not the director.
That's a great point, Bob, because when I was the corporate secretary, we spent so much time with the board socializing the board meetings and the committee meetings to make sure that everyone got them on the calendar early, and then if there were potential conflicts with other boards or other businesses, that they could clear them, or we would come up with an alternative date. Yeah.
Yeah, which again is why so many companies plan their board schedules, 2 years or more in advance.
Thank you very much.
Thank you. You're very welcome, sir, madam, whatever.
Thank you so much.